Now we are.
Live. Rita, it's live. Rita, you want to go ahead and get started? It says it's live.
Okay. Hello, everyone. My name is Attorney Rita White. I'm the current president of the Black Women Lawyers Association. I would like to welcome you all to this, to our People's Law School, which we do regularly hold. Our last event was probably about coming close to a year ago, around last summer. And what we do is we actually help and try to promote education in the legal sector by bringing in all of our esteemed attorneys and lawyers and members of Black Women Lawyers to talk with community members about different issues, legal issues that they may have in our community. So today, my name is, again, Attorney Rita White. I'm a criminal defense attorney primarily. I practice primarily criminal, child welfare, and I do a lot of appellate work. So I've been practicing for approximately 20 years. And I have my own private practice, and I've been in private practice for about 11 years. Previous to private practice, I was an assistant prosecutor for 10 years with the Wayne County Prosecutor's Office. My office is based in Plymouth, Michigan. However, my primary area of practice where I litigate most of my cases is in Wayne County in Detroit. So if you are looking for an appellate attorney, a criminal defense attorney, I can be reached at 734-334-3236. And my website is cantoncriminalattorney.com. Now, along with myself, we have three esteemed panelist attorneys. The first one is in the far upper left corner, and her name is Attorney Victoria Burton Harris. And she is a practicing attorney and currently a candidate for the Wayne County Prosecutor's Office. And then we have, wave your hand, Victoria. And we have to the far upper right, we have Attorney Mandy Wilkerson. And wave your hand. And then we have to the bottom right next to me is Attorney Robin McCoy.
Hello.
So, yes. So first, what we're going to do is we are going to have each panelist provide a brief opening presentation statement of who they are in their area of practice. And then we will field the live stream for questions. So first, Attorney Burton Harris.
Thanks so much, Rita. I appreciate that. Again, my name is Victoria Burton Harris. I practice criminal law and family law. My office is located in the heart of downtown Detroit in the Penobscot building, which is about 2 blocks from Hart Plaza. I can be reached at 313-246-2166. My website for the firm is www.mccaskey.com.
Thank you, Victoria. Ms. McCaskey. Ms. Wilkerson, attorney.
Hi, my name is Attorney TILMANDRA WILKERSON. I prefer to be called Mandy Wilkerson, so that's probably what you see on the screen. I am a solo practitioner and founder of WILKERSON LAW, PLLC. I run a pretty general practice. However, I specialize in criminal law. Prior to starting my own law firm, I was a former Wayne County prosecutor, so I do have a background in on that side of the criminal law as well. And I can be reached at 248-505-4237 or at my email, wilkersonlaw1@gmail.com.
Thank you. Attorney McCoy.
Yes, hello everyone. My name is Attorney Robin McCoy. I'm actually the Vice President of Black Women Lawyers in Michigan. And I've been practicing, it's probably been about 18 years, and I specialize in criminal defense, family law, and educational advocacy. I'm a professor at EMU. I teach a class on law and the African American experience. And I hope everybody is keeping safe and shut in, or if you're out and about working, that you're making sure that you're protected. And we have been to law school, we've done it in the past, and we thought, okay, even though we've got a global pandemic, people still need to have the benefit of legal services. And so we put together we have these daily panels of attorneys that are talking about different subjects. I know yesterday they did family law. Today we're doing criminal law. And we just want to make sure that we're getting the knowledge to the public, to the people. And so I think it's very important that we do that. And then my number is 734-769-0001, 734-769-0001. My website is McCoyandassociates.com. And I also have another website. It's called Robin Legal, where you can find out I do free educational videos on what to do when stopped by the police, how to navigate the public school system, and expungement. And I just think it's important that we have this knowledge base here. We have these esteemed panel of attorneys, making sure that the public gets the knowledge, make sure that their rights are protected. So again, I'm glad to be here. And I'm going to turn it back to Rita, our Madam President.
So yes, now what we're here for is if people have questions, this is a very, I guess, a crucial area because it's very novel. This has never occurred clearly in my lifetime. Have we had an era like this where we've been pretty much quarantined and been required to stay at home based on an outside factor that's affecting many people worldwide. So this does affect the criminal law area. And we do have some questions. And so if you have questions, feel free to type them in. And then what will happen is I will review the questions and then probably most likely just farm them out to the panel. So our first question is, what is a preliminary examination and should I waive it? I'm going to hand that to Attorney Robin McCoy, and she can answer that.
Okay, so a preliminary exam, actually I'll start with what before a preliminary exam, the legislature put into place what's called a probable cause conference. So that's usually if you have a felony case, that's the first hearing that you have. And the question that comes up at that hearing is whether you should actually hold the preliminary exam hearing. And the preliminary exam hearing is actually, we call it a probable cause hearing, and where they decide, the burden is on the prosecution, and the cases are started in the district court, and it's issued. You have a district court judge, and they're evaluating whether the case should be bound over from the district court to the circuit court. And so it's very important that you consult with your lawyer. Ideally, you would have your discovery on your case, and you've had opportunity to talk to the lawyer with enough time to make this critical decision of whether you want to hold an exam or not. Oftentimes, if you hold the exam and the prosecution doesn't meet the burden, doesn't have enough evidence, the case could be dismissed. There are some times, though, where, and that's why we have a prosecutor's race coming up, where the prosecutors, we've been trying to get on them about that, where they'll say if you hold the exam, they'll increase your penalty, which I think is wrong and unethical. It's like a mini hearing, and the burden's on the prosecution. And I know, like, when you get to a trial later on, a client wants to bring up the full evidence, and some clients want to bring that up at the preliminary exam. And I tell the client, typically you don't do that. You put it on the prosecution. They have to show the evidence, and so if they don't have the evidence, the case could get dismissed. And so that's pretty much the basis for a preliminary exam. Oh, I see we have Christina has joined us.
Yes,
Hi, Robin.
Christina.
Hi, ladies.
Hi.
Sorry, a little late. We're getting used to all this online technology that we're using to do our conferences. Good morning, everyone. Good afternoon, everyone.
Good afternoon.
Sorry,
Yes.
Rob. I didn't mean to interrupt you.
Oh, no. I was just talking about the basics of a preliminary exam. Your lighting is a little low, though. Are you able to add some kind of lighting to?
Maybe I can change my position a little bit. Let's see. Is that better?
It's a little bit better. The light, I can see when I saw the light from the ceiling, it was a little bit better. Yeah.
I don't know how to. I'm sorry, I didn't mean to be so dark. Maybe it's my glasses that see me better.
Yeah, maybe because what I did is I just turned my computer facing the sun. If I'm out, if there's a sunlight, so the sun can kind of glare. So
the brightness on my computer is kind of up, but maybe what I can do is change a little bit of the contrast here. Should I be this one? Go back to the table.
What I did is I added a little bit of I added some light, like look, if you have a lamp or something that you could add, that might help.
Okay, so while you're doing that, Christina Stockdale has just entered, and she's a practicing attorney, and I'm going to have her introduce herself when she's ready. That looks better.
All right, ladies, can you see me now?
Yes.
Is that better? Okay, awesome.
So,
Hi,
Attorney McPhail-Stockdale, if you can introduce yourself.
I can, thank you. My name's Christina MCPHAIL-STOCKDALE. I'm an attorney. My practice is located in the city of Redford, Michigan now. And I actually practice in 14 different areas, but one of my growing practices, and probably almost over 65% of my practice now, is in cannabis law. I do represent several different commercial cannabis companies, consulting agencies in the cannabis industry, grow facilities, dispensaries, what have you, engaging in everything in variants of advocacy to draft and propose legislation to municipalities. I participate in various boards and cannabis groups in regards to ensuring equitable and fair opportunities for minorities and women to participate in the industry, to combat some of our previous very discriminatory practices or state discriminatory practices on the prosecution of various drug laws that have affected our community. So there's a variation there. My husband, who himself is a marijuana grower, licensed out for a grow facility in the city of Inkster. I serve as chief counsel for that company, and some of the other commercial cannabis companies in the area as well there. So it's a very exciting area of practice. I had a long time conservative views on marijuana. We knew that from representing criminal clients who had been charged with various drug crimes, that I would then be on the other side of it, on the commercial end of it, to help them engage in the business. So that's kind of where I fell into that.
Okay, great. Now, just if the panel members, there's a little bit of feedback. So what I'm suggesting is that whoever is not speaking, if you can just keep your speaker muted, maybe that, because there's a lot of feedback, and I've been receiving some responses from that. So I'm just trying to see if we can cut down the echo, which it's gone away. Okay, so let's go back to our the preliminary examination question. Let me just really quickly, Attorney Burton Harris, if you can give your kind of your feedback on the preliminary examination question.
So yes, as Robin explained, it is the second hearing that you'll have following the probable cause conference. And the easiest way to think about the exam and the purpose is in a two-step way. One, it's an opportunity for the prosecution to A, prove that a crime has been committed, and then B, prove that you committed that crime. But in addition to that two-step question, it's also an opportunity for you to see the evidence that the prosecution has, some of it, maybe all of it, to get a feel for how officers or a complainant, also known as a complaining witness, will testify. It's also an opportunity, if you decide to hold it, and that's a decision, again, as Attorney McCoy explained, you make with your attorney prior to the exam based on the evidence and the facts of the case. But it's an opportunity, if you're going to hold the exam, to submit a story in stone, because what is testified to at that preliminary exam will forever be the testimony that you can either use later at a trial. It's oftentimes used during the appellate process. So again, if you're going to hold it, your lawyer will more than likely get the most bang for their buck with that exam if they play their cards right. Now, we talk about holding, so I imagine the question is, well, what if I don't hold? Why shouldn't I waive it? And questions of that nature. So you oftentimes are going to be advised by your attorney to not hold an exam. Those reasons can vary. Oftentimes the reason is the evidence is quite clear. It is not necessarily in your favor. And holding an exam can open you up to the prosecutor moving to amend and add new charges based on the evidence that's likely to be produced at the exam. Now, is that a reason that I advise my clients in all cases to waive? Absolutely not, because as, again, Attorney McCoy stated during her presentation to the answer to this question, oftentimes prosecutors will threaten to move to amend and add charges even if you hold it, whether the evidence supports it or not. So that's a decision that should be made on a case-by-case basis with your lawyer advising you. But at the end of the day, you as a client, I tell my clients this, you're in the driver's seat. This affects you and your life. If you feel that you have been well informed by your counsel, yet you still want to proceed with the preliminary exam, you have an absolute right to do that. But it should certainly be an informed decision.
Okay, thank you. Attorney Wilkerson, do you have any comments regarding that question? Yeah, if you can unmute your phone.
Sorry about that.
It's okay.
Just a little to add, I know Victoria spoke briefly about reasons why you might want to waive it. I just want to add in a little about reasons why you might want to actually hold it. Sometimes your lawyer can look over the discovery, which they should have before the preliminary exam, and determine that there are some things that are missing or that the prosecution may not necessarily be able to prove. And that's one of the main reasons I believe that it's beneficial to the client to hold the preliminary exam, because sometimes it's a way to beat the case before you even make it to trial. Like, it cuts out a little bit of the legwork if there are some things in the charge that the prosecution cannot prove at the preliminary exam stage.
Okay, great. So yeah, we're going to go on to the next question, but just as a piggyback from all the responses, one issue is make sure you're just work with your attorney, because your attorney is the main person that's kind of driving the vehicle in a way at this stage with the preliminary examination. Because a lot of issues that I've come up with in my practice is you have to make sure your attorney is going to review the discovery, which is the actual the report, the police report, the investigator's report that they receive. And there are times when I review the report that I see issues that if the exam is held, I personally will see that there is a possibility that charges could be added, because in my mind, putting my prosecutor's hat on and being a defense attorney, I was in a position where I did sign warrants and review warrants and actually sign charges for cases. And when I review reports, I will see things that could potentially be charged if we do hold the exam, if they do decide to hold the exam. So I will always advise my client that if we hold the exam, be aware that charges could be added based on these allegations that I see in the report, that if the complainant, the victim testifies to, may be added. So there's a lot of different factors, but we all have to, it's a balancing test, because again, as all the attorneys have mentioned, it's a probable cause hearing, that it's just a hearing to establish the charges against the individual. So if there's issues that that it's pretty much, it's a case that really it is what it is. And either way, most likely it's going to be bound over by the minimal amount that the prosecutor needs to present to the judge to have it officially, converted into an official charge. You may want to look at waiving it. But if there's issues such as identification, most likely the complainant may or may not show up, or there may be issues that you clearly see that could actually potentially dismiss the case. That's where you have to make a balancing factor as to, do we hold the case to basically guarantee, we are pretty much guaranteeing a potential dismissal based on the evidence we've read and reviewed and the potential of the complainant not showing up? Or are we going to hold the case and charges are going to be added? Are we going to hold the case and it's pretty much from what I reviewed, and there's statements, there's identifications, that it's pretty much a strong chance that a judge is going to possibly believe that the crime was committed. So it's a balancing factor. So you need to work with your attorney on that matter. So the next question is, if the people ask me to talk and they are not going to arrest me, what should I do? Who would like to answer that? Whoever goes first.
Go ahead. You absolutely should not speak to anyone other than your attorney. You do not speak to the arresting officers. You do not speak to people in a holding cell. You do not call anyone on the telephone and you say what you may have done, what you think you did, what you actually did. You don't say anything to anyone. And I explain to my clients using a visual. Imagine that there are various holes like that triangular game that they have at Cracker Barrel, right? You take all the pegs out and there are just holes that remain. That's the case when it first starts, okay? And the police are there ready to put a peg in each hole, and the pegs that they receive oftentimes are from folks charged with a crime. You give people that work in the system, the prosecutors or the police officers, you give them the pegs to complete this board, which will nail you when you talk. When you talk and you try to explain yourself, you didn't mean any harm, but you did this. Your intent wasn't criminal, but you did that. Well, every time you open your mouth, you're just giving them pegs. And as long as they can put pegs in a row, they are on their way to nailing you. You will never talk yourself out of being arrested. If they're going to arrest you, they're going to arrest you. If they choose not to arrest you, they can't. They don't have enough to. And they're hoping that if you talk, you'll give them enough to arrest you. So don't do that. We tell you all the time as attorneys, you hear it on TV. There are funny little tidbits on YouTube. Shut up. Don't talk. I say that. Be quiet. I'll say it lighter. Be quiet. Don't talk. You're only hurting yourself, and you make our job so much harder as your defense attorney later.
Yeah, if I could just add to that, what Attorney Burton Harris just said. For those of us, who we're criminal defense attorneys, a lot of times we'll get cases and we are put in the mode of damage control because people have given statements. They've let the police come into their car, their house, search them on the street. And we're put in the position of damage control. And that's part of what motivated me to start doing programs. And I know Rita's been on one of my panels on what to do when stopped by the police. And that's one of the biggest takeaways that I tell people is when they're dealing with the police is I say, zip it. And I talk to kids about this too, zip it, because what people don't understand, I know people, they get in a situation with the police, they're scared, and they'll start talking, and then they don't understand. The police will take that information, they give it to the prosecutor. The prosecutor will decide whether to charge based on what you said. They have, like Rita said too, like they're looking when in the prosecutor's looking for certain, they have a checklist and they want to make sure all the checks are made. And if you give a statement, if you give an admission, and then the police have other evidence, it's a slam dunk for them. So I have a case right now where my client is being investigated, and the officer reached out to me and said, well, I want to talk to your client about giving a statement. And I said, well, it's probably not likely going to happen, but I'll talk to my client. But I'm like, because we're not going to help them to make a case against a client where they have none. I've had situations where, and that's why, it's good that we're having this program here. And I encourage people to have initial consultations with lawyers even before you talk to the police, because we can help you prevent a case from happening. We come in, bring the people in the office, go over your story, and we can tell you. I've had cases. I had a young man that was accused of doing some inappropriate stuff with another young lady, and the police wanted a statement. And I talked to my client and his mom, and I said, no, don't give him a statement. I know a lot of times we want to be helpful, but the biggest thing you can do when you get stopped by the police or questioned is to zip it and ask for a lawyer, and the lawyer is going to tell you to zip it. Don't give a statement. And, certain situations, like if you're in your car, obviously certain situations, you want to give them your name, and you don't want to, you don't want to elaborate. You want to keep it short. And if you're not under arrest, you can just say, am I free to leave, and leave, and don't stay there. And, there's situations. The Supreme Court said the police can lie. They can trick you. I've had cases, and I'm sure the ladies could probably share some of their situations. I had a case where the officer promised that he wouldn't charge my client if he was helpful, and my client was helpful. And then the officer admitted that he did say that, but it's not up to the officer. It's up to the prosecutor to decide whether to charge. So zip it. That's my biggest thing. I can't say it enough. Zip it.
Anyone else?
Anything else to add?
I agree with both what Victoria and Robin said. I think what I see a lot with most of my clients are the younger clients who, like Robin said, are afraid. They more than likely feel like this is the police. I have to talk to them or I have to say something. And my advice is just to know that you do not have to talk to the police. You do not have to tell them anything. Just because they are a law enforcement officer does not mean you have to tell them everything. Like Robin said, your name, giving them your ID during a traffic stop, and those sorts of things are okay. But anything, absolutely anything beyond just maybe identifying yourself, you don't have to tell the police. Just because they're the police, they can't arrest you for not talking to them. But they can arrest you once you do talk to them and give them information that they need. As both ladies said, they're building a case. They're not trying to help you. I hear a lot of clients say that the officer was nice to them, or they felt like the officer was trying to help them. A police officer is never trying to help you in a criminal case because their job is to help the prosecutor. They cannot help a criminal defendant because it's a grave conflict of interest. Their job is to work for the prosecutor and help them build their case. So anytime a police officer appears nice or appears to want to try to help you is really just, like Robin said, a trick to get you to talk because they need information from you. So yes, I agree. Absolutely, do not talk to the police. Do not say anything. The only thing that should come out of your mouth when speaking to the police in relation to a criminal charge or investigation is, I want to talk to my lawyer.
Attorney Chris Stockdale, do you have any comments regarding that question?
Let me unmute my mic. Can you hear me okay?
Yes. Yes.
No, with regard to what the ladies were indicating, I agree 100% on that. I think that it's complete manipulation to try to get any individual to speak or engage in it. But that's what officers do. It's easier, what they indicated. If I'm hearing the question correctly, it's easier to try to get the elements of crime resolved by an admission by the person being detained than if they were to be afforded the opportunity to have counsel. And you have to remember, our Supreme Court has upheld that officers can be deceptive and lie during the process of interviewing an individual. And if the person agrees and consents to that interview, then unfortunately, and that is, as the ladies pointed out, we hate that for our clients. Sometimes the steps aren't followed. Sometimes there are things that are inappropriate. It's not to say that we're trying to help someone get away with the crime. That's not what it is. When we defend people, when we help them on a case, and even under unfortunate circumstances where they did it, you have to remember that the rules that we have in place, the laws, the constitutions, the preservation of those rights benefit everyone, even those that are guilty. Goes back to the old Bible stories about the Lord not destroying the land if only, even if 100 guilty people are there, but if one person, it's worth the preservation. So those have always been my motivating factors, because you never know when it's us in the hot seat. So we fight for the preservation of those rights, not necessarily to engage or encourage someone to get away with the crime. There are rules and protocol for a reason. So please, if you're watching this, make sure you honor the right to shut up. The golden rule of silence is a beautiful thing, and it works to your advantage as opposed to your disadvantage.
Thank you. So just real quick, I agree. That's all of the comments are definitely very relevant and pertinent to this issue. We all know that there's a constitutional right, and there's a reason why the Constitution has been put in place. We have a right to remain silent. And just one issue with this, an issue with this matter is, with cases, there's two sides to actually proving a case. Not two sides, but there's two elements. You can prove them through circumstantial evidence or direct evidence. Now, I've had many cases, unfortunately, many cases where they were very, very circumstantial. And that means that there's no direct evidence showing or proving or establishing that anyone can show that you committed that crime. However, through circumstantial evidence, such as people that you were at a car and pretty much the car was stolen, and then someone saw you in a store walking towards the car, and then you were the only one walking towards the car, and then the car was taken, and then the circumstantial evidence turns into you made a statement that you took the car. And then since there was no direct evidence that you took the car, all that comes together. So as all the attorneys are saying, I always tell my clients, do not say anything, because really officers are trained to actually interrogate individuals, and officers are trained to deceptively interrogate individuals, lie and indicate, oh, well, I'm just trying to help you out. I'll help you out. I'll give these charges, this, that. And then if you tell me what happened. And you have to be very aware that the officers, if they ever ask you a question about a case, be very, very pertinently aware that they are asking the question to actually use you to create the case against you. You are their actual workbook, okay? So don't ever think that they're working in your favor. They're using your information to create the case to take it against you eventually. So never, ever talk to the police, regardless of how they come to you, even not even the police, if you're at a mall and you're charged with retail fraud, and the store owner comes to you and states, oh, well, give me the items back and just write a statement that you took it and we won't prosecute. Never, ever do that. Because just because they say that, we will never call the police or we will never prosecute. I've had many cases where they say that to the client, and then what happens? They turn around and they have a warrant charged against them. So never, under any circumstances, you have a right to remain silent. Now, does anyone have any other comments? There was a question. It went away, but I think Attorney Stockdale would probably be the best to start with the answer. And the question is, what does a $50 fee for a salesperson LARA license versus a $6,000 fee mean? Or what is the relevance of that in terms of the amount?
Okay, I was trying to figure out what the person actually meant by this question, because it's confusing to me. Let me just kind of break down what I believe what they're assessing on. First, when we're talking about the $6,000 fee, when you're applying for a license to operate a commercial cannabis company, whether it's a grow facility, whether it's a dispensary, in this case, the state of Michigan has 5 different licensing schemes for the commercial cannabis industry: growing a cultivation facility, a grower, the provisioning center, which is our dispensary, processing, typically dealing with extractions, working with marijuana derivatives, where we would see Rick Simpson oil, CBD, so forth. Then you have secured transportation. And then you have the testing and compliance. These are our labs to ensure that the marijuana at issue being serviced or being sold is fit for its purpose, that it's not molded, doesn't carry any other toxins or things that could be, of course, compromised to the user, to the person who indulges. So there's 5 different schemes here. Now, this $50 fee for a salesperson LARA license, the only time I see that is in real estate. So I'm confused on the question. I apologize, I can't answer it, because when you're applying for an application, there's a one-time $6,000 application fee that has to be paid at the time you submit the application. And again, this is the state licensing fee that's paid. There is a $5,000 fee that's also paid for an application, but that's at the municipal level. And you pay that there also with the city who has opted in to engage in this business. And you pay that for each license that you're applying for at the city level. But then when you apply at the state level, there's a one-time application, $6,000 fee. So Mr. Fay Milton, who I believe is the poser who inquired about that, if you could elaborate or submit another question, what do you mean about the $50 fee for salesperson lawyer license? That's unrelated to cannabis, unless there's something that I'm not familiar with. I don't pretend to be the grand know-it-all. But if you could explain that further, and then hopefully I can answer your question better.
Okay. So the next question is, do I have to have a licensed medical facility to obtain an adult use license?
Yes. And it depends on the licensing that you apply for. Now, Michigan has decided that instead of just giving these licenses to the big companies or the they wanted to carve out a niche under the micro business licensing. That license allows you specifically to sell adult use or what we call recreational marijuana to individuals of 21 and older without having to have a provisioning center, without having to deal with a grower or so forth. You can cultivate, grow, do your own thing. You can sell it to the market. You're limited on the number of plants that you can do this with, but you can sell it out in the open market. It's 150 plants typically under the micro business. So you have to have some licensing scheme to be able to have the adult use license. Now, your city has to engage and adopt an adult use statute before you can even do that. So, for example, the city of Detroit hasn't enacted a adult use recreational licensing scheme yet. They're on the verge of hoping to do that. Hasn't done it yet. So someone wouldn't be able to do that in that city. But a city like Ann Arbor, who has, of course, you would be able to apply for an adult use license as a micro business, as a facility, or as a dispensary because they have done it. Now, our law currently requires that you have a medical use facility, the medical license to actually obtain the adult license with the exception of the micro business. So if you, for example, are someone who wants to cultivate and have a grow facility, and say that grow facility you want to sell 500 plants recreationally, you can't do it unless you were certified to do it medically. So that law is in place for 2 years before they either allow other states to come in and do strictly just recreational, unless they allow other individuals to come in and just be able to license this grow recreationally. But you had to have had the medical clearance first before you can engage in recreational. And again, you can only do recreational if your city has enacted the appropriate legislation that allows you to do so.
Okay, so now the next question was, how much does someone have to basically expect to spend to enter the cannabis industry?
It's expensive. We're not dealing with just basement growers or just caregivers and few plants. The regulatory fees have enlarged a little bit of the and the financials that are needed to be there. So, for example, let's talk about a grow facility. Generally, one of the licensing application requirements is that you show a certain amount of financial uh, stake, financial wealth of your company or certain financial holdings. So for example, an individual who applies for a Class C license to grow at minimum 1,500 plants typically have to show about $500,000 in assets. It doesn't have to be all cash. A third of that typically has to be cash. So you're looking at about $125,000 that has to be in cash, and the remainder has to only be just in assets. So just in that in itself is a requirement. Of course, these dollars through due diligence, through the pre-qualification stage, they inquire as to the source of those monies to ensure that they're not coming from illegal gains or some other criminal enterprise or activity. In addition to that, just the licensing fees. Each license, once you get approved for your license, it can vary anywhere between $60,000 if you're talking about grow facilities and dispensaries, or transportation is a little bit lower. So that's just to have the license to operate. That doesn't mean the application fees. That doesn't mean the architectural fees. You have to have site plans if you're doing a grow facility that gets approved by the city planning commission. So you have to pay for your architect. There has to be plans that involve the safety and storage of your cannabis on site, a security plan. Some cities, depending on the resources of their officers, have enacted legislation that requires the commercial cannabis business to pay into the general fund to ensure that officers are available to help secure a cannabis facility. So there's a big range. It's not a set number. Is this a business you can get into with just $100,000? Perhaps if you're doing a micro business, um, or some other type of consumption license, which they have now, again, to kind of help the mom and pop or smaller businesses. But generally, you're easily looking at, between attorney fees and so forth, spending upwards of $750,000 and up. And again, it depends on the license you're going for, the size of the facility. It is a very intensive process, and it requires much capital.
Okay. So the next question, I'm going to direct this to Attorney Burton Harris. Can the prosecutor issue an arrest warrant for you and not tell you about the warrant for months or years?
Absolutely. And it happens all the time, especially in Detroit, where, we have a large transient population, which means that people move often. And not only do people move often and not update their information, but oftentimes people are couch surfing and they're technically homeless. And so when you talk about notice to folks, that notice is not there. It's not like notices go out on your cell phones. They oftentimes are never mailed out to your home. Sometimes you get a notice in the mail, but more than likely, you find out that you have an arrest warrant when you're pulled over for a routine traffic stop. And at that time, a police officer will tell you that you have an active warrant, and they're going to make a phone call to the jurisdiction that put that warrant in and ask if that jurisdiction wants you. And if they want you, then the police officer is going to put you in the back of the cruiser and take you to that jurisdiction. And you won't have a way of knowing what's happening. Maybe an officer will tell you. They don't have to tell you. And you just are forced to cooperate. And so what I tell people, if you think that there's a possibility that you have any kind of an active warrant, you can find out in Michigan by doing an iChat search. And it's a Michigan criminal history search that you pay $10 for. If you Google iChat, you'll see the link pop up. Have a debit card or a credit card available to pay the $10 fee, enter your first and last name and your date of birth, and you will be able to see if there are any warrants active within the state of Michigan.
Okay. Yeah, that's true. And that's, yeah, if you have, because a lot of these cases, it really depends. A lot of times, if a prosecutor issues a warrant, depending on the severity of the case, sometimes it's really up to the police department to either decide whether they're going to come after you and, put a, mail on your door or a knock at your door to let you know that you have a warrant, or they just may sit on it. So really, in terms of what you would call statute of limitations, it depends, because if it's a serious case, such as, a homicide or a CSC, as you see, criminal sexual conduct cases, you see there's a lot of what you would call cold cases that have been sitting out there in the crime lab for years, and there's been nothing done. That's the thing. So they can sit there and they don't go after the individual. So if you believe that there may be a case against you, as Attorney Burton Harris, you look into iChat. But what I would just advise is you contact an attorney if you're concerned. And the attorney, now that, especially given that we have COVID that's arisen. Most attorneys are working through electronic means. And before this COVID situation came into play, there has been a lot more movement in terms of online electronic access. So what I would do is I would just go on to either the district court website, or actually the the Odyssey, which is the Third Circuit website, and pull up the case code, and then you would be able to see if there was a warrant requested under your name. So yeah, it's good to check if you're concerned. But like I said, if there's a warrant, you would have to do your own homework, because sometimes officers, they will sit on it and not pursue you. So in terms of another question, the next question is, will my criminal history prohibit me from taking part in the cannabis industry?
It actually can. There's regulation issued that specifically prohibits individuals from being principals in companies in the commercial cannabis industry when you have drug convictions. Typically, there's some scrutiny on that. There's been some lax treatment on that, depending on how old the conviction is. There's generally a 10-year rule with regards to that conviction that may keep you from being engaged. It's really a case by case. I think that under our current governor and the panel that we have in place being excluded, they may give some consideration to individuals, but traditionally, traditionally that has been something that has excluded individuals from the business. Now we do have what's called social equity. Social equity is essentially a legislative scheme to give individuals who live in communities that have suffered hardships from tough drug prosecution that has led to perhaps the disproportionate number of individuals, minorities likely, being incarcerated and so forth. So they came up with the social equity scheme, which is tantamount to being like affirmative action for weed, by saying, you know what, if you live in a disenfranchised city, like a Detroit, your Pontiac, your Inkster, again, disenfranchised being cities that has suffered disproportionate amount of convictions related to drugs, that you may qualify for a discount on your licensing for a commercial cannabis business. And then they have a criteria of different points that you can get. It could be that you lived in this city and you're a resident for 5 years or more, you have the conviction, or you this or you that. There's some very, very serious different types of criteria to determine your eligibility. But the problem still is that even if you get a 25,000, even if your fee goes down to 25,000 from maybe 60,000 to have a commercial business, the problem is still having the capital, having the $25,000 to engage in the business. So there are opportunities for people who have the conviction to get in. It just varies. It varies under the social equity statute. If your city has adopted a social equity scheme, some cities haven't. But there is an opportunity. We work with a lot of groups trying to help advocate for the opportunity for people who have prior convictions, who have changed their life, that want to get into the cannabis industry. We just have to be creative about the routes as to how you do it.
Yeah, I would add to that. I know that there are some of us that got together, and I want to say it was this last summer, and we put together a redemption coalition, and we had some of the representatives from the cannabis industry. And so traditionally we were doing, as Black Women Lawyers has helped to sponsor some of the expungement workshops. And that's one of the big issues that we were talking about. Like traditionally what we would do is we do workshops where we talk about the expungement statute. We go over the application with everyone. But what we decided to do is have a partnership with some of the state reps. So we had the late state rep, Isaac Robinson, and we had Sherry Gay Dagnogo, Tanisha Yancey, and we started doing workshops. You can look at some of those workshops on my Robin Legal website. And also the last time we did the People's Law School last summer. I also have that video from when we presented on different areas of the law. But that's one of the big issues that we've talked about as far as Michigan, is that there's a disproportionate number of Black people and poor people that have criminal convictions, and that we've been penalized for selling marijuana. And then now you legalize marijuana here in Michigan, and Black folk are hindered from getting into the game. And so one of the last workshops that we did was on December 8th, and it's on the Robin Legal website. And it was sponsored by the late state rep Isaac Robinson, and we brought in Rick Ross, and he was able to get his record did not hinder him. He had he's considered a Rick Ross, the real Rick Ross, as I learned. And he was talking about what he was able to do as far as being able to get into the cannabis industry. And he's trying to help other people to get into the industry, Black folk, like what attorney Christina has talked about. And Christina, make sure you share your phone number. We all want to make sure we all share our phone numbers and contact information. And Christina, I would say, I'm in school listening to you. I'm like, we should have a separate session just where you talk to us about the stuff in the cannabis industry, because I'm learning some stuff here right now. Because
we've been doing the expungements, and that's exactly, it helps. But the problem was that when the state in the application, even in the legislation, didn't even care if you had an expungement, you were still excluded from participating in the cannabis industry. So that was a problem, that even if you 30 years ago and you got the expungement, you could still be excluded. So we work with the state. There are some reasonable people at Laura that understand the inherent unfairness. Now remember, they came up with social equity now they're in light of us having recreational marijuana. They didn't have this at the time when we were dealing just with the businesses that were getting in on the medical end of things. So, Robin, you're hitting the note that to keep the expungement fairs going, these applications are being considered, and there are people with the convictions that are being allowed to engage in the business, but there's a lot of scrutiny on it. And it doesn't even get to the state at the city level. If they see the conviction, your application is denied. And you have to first get approval from the municipality of which you're going to do the commercial cannabis business in before you can even apply at the state level, because the state application requires your letter of approval and award from the city of the licensing. So it is a problematic issue. I work with the HR, minority-owned HR staffing and solution firm known as Isla Verde, also located in Inkster. And Isla Verde is specifically helping to recruit, train people for the industry, because you need workers for these commercial cannabis businesses. And they're also engaging in helping with the expungement. And they coordinate with my office to try to help some of their job applicants and who are seeking job placement in the industry and have these kind of records. So it's a challenge, and there are a lot of people who are shut out specifically just from the conviction, and they're older.
Yeah. And that's unfortunate. And I mean, I think that's why we probably I know we're talking about doing this again next month, so we probably should just have another session with all of us talking about expungement, how to expunge your record. And then I would say back to Victoria, that's why the importance, we have Victoria that's running for the prosecutor's office in Wayne County, and you have other states where when they legalized marijuana, they also cleared people's record. They cleared their criminal convictions having to deal with marijuana, and Michigan has been doing it piecemeal, and it's unacceptable. You look at Illinois, California, they've been way more progressive. Even Ohio has been more progressive. Michigan, it's 1 felony, 2 misdemeanors. And we have been, my mama said something about Michigan being like the Mississippi of the North. We are slow. And so that's why it's like, we got to get on it. We got to have more of us running for state rep, state senate. We got Victoria that's running for the prosecutor's race. We got to make sure that there's criminal justice reform in the prosecutor's office, and that these issues, like people in Detroit, are heavily impacted. I mean, I know a lot of us can talk about cases. I practice in Wayne, Washtenaw, Oakland County, but a lot of us can talk about a lot of the people we deal with. that we represent are Black, young Black, a lot of males who got caught up in the drug scheme. And whereas you have with the white community, they're more compassionate. They're doing drug treatment. They're more compassionate. And we need some compassion too. It should be equity demands it.
And let me also jump in and say that while we are waiting for that package of bills to be signed, we also underestimate the power that our county has. Your current county prosecutor and your next county prosecutor, they can work for $15,000 to automatically expunge marijuana convictions. They can work with Code for America, the same company that has been utilized in other states like California. And the budget for it is a mere $15,000 to do a blanket erasure of all marijuana convictions, because that actually will give people fair opportunities. Because we know when people have opportunities to live, to have jobs, to take care of themselves and their families, they're less likely to go out and commit crimes out of necessity because they have been given an opportunity to live and to thrive and survive. And that's what really expungements amount to allow people to have a fresh start. I know police officers, police chiefs in Wayne County, chiefs of smaller cities have met with me and said, Victoria, blanket expungements, automatic expungements would do wonders for my officers, because we would not have as many problems as we have on the street responding to crime if people had opportunities to work. But they don't, because of, the failed war on drugs and these marijuana convictions that are holding people back. That's now legal. How fair and equitable is that?
And you know what? I'm glad you said that, Attorney Burton Harris, because it's not just the possession charges that need to be cleared. We also have issues regarding that was deemed unconstitutional by our state Supreme Court was unlawful transportation of marijuana. This had been a problem where if the person had a visible patient card or caregiver card, but then what officers would do is then say, you know what, you needed to transport your marijuana like it was a firearm. It should be in the trunk in a locked case. And that's not the law. And specifically the 2008 Medical Marijuana Act specifically provided protection on that very issue. But yet it was a scheme for prosecutors' offices to use that um, to, I don't know, generate revenue, create enforce conviction records for individuals. And even though it was deemed unlawful, and now that law is no longer on the books, it didn't have any retroactive activity, and now it is used against people from engaging in the cannabis business, even though it technically wasn't a possession charge, it was unlawful transportation. And they have fines and fees to pay for that, probation. And we know that sometimes people don't do well with probation. So these things spiral out of control from the very thing that they should have never been convicted of in the first place. It's a community effort. It takes change at so many different levels.
But it has to start at the top. It has to come from the leader down. If you don't set that tone as the leader down, then no one in your community is going to rally against or rally for it, right? So it is imperative that our leaders say, you know what, Lansing? You haven't quite gotten it yet. You got some folks in Lansing fighting for expungements, but it hasn't gone very far because others are opposing it. I'm not going to wait on you, Lansing. I'm going to take charge of my county, and I'm going to, again, use a mere $15,000 of my budget to bring automatic expungements here because it is holding so many of us back.
So now we're going to go into the next question. The next question is, if I get arrested during this COVID pandemic, are the courts still going to still doing cases, or will I be in jail under the until the quarantine is over? Mandy, would you like to answer the question?
What I've been seeing in dealing with cases during this pandemic is that more of the serious cases are being handled right away, and they're doing it via Zoom video hearings to get people arraigned and hold bond hearings and those type of things. So I would hope that no officers are out here arresting for things like driving with license suspended, but the courts have implemented ways to get cases worked on during this pandemic via video, where you will be able to speak with your attorney and have an attorney present, and the hearings are being held. So to answer that, no, I don't believe anyone will have to stay in jail until this quarantine is over. As long as you're able to have a bond hearing and an attorney to argue your bond and get you out, then that should be no problem, because they are doing video hearings to handle those cases.
So in terms of these issues with COVID, I was just actually listening to an interview where the Chief Judge Timothy Kenny, was being interviewed in terms of the actual, the status of the court and how the cases are actually processing during this COVID pandemic. And he did, if you can mute your phone, whoever has their phone off mute. So if that there was some comments regarding the actual extent of how cases are being processed. And Judge Kenny did discuss the fact that percentage-wise, the number of cases, actually the number of people that are incarcerated, there have been many people that have been released. However, the number of people that are actually, the charges that are coming through the court have been dramatically reduced. And clearly, the court did indicate most likely because the police are not pursuing individuals. And the first stage that it comes to is the arrest. And the main issue is, if you get arrested during this COVID pandemic, are the courts still doing cases? Yes, they are. But really, you have to look at, are you going to be arrested? And if you are going to be arrested, are there going to be charges against you? And the numbers are definitely dramatically reduced based on the circumstances. So the next question is, when do I get to tell my side of the story during a criminal proceeding? Now, this question was already asked in a different manner previous. So again, don't talk. This is not an area where you should say anything. However, before you're charged, and before you actually received a criminal charge in the mail or on your door, you can go to the police department at any time and talk to them and tell them your entire side of the story. You can write a book and present it to them. You can say whatever you want, but just again, be mindful that whatever you say can be used against you. Now, if you are charged with a criminal charge and you receive notice of that, from that time on, if you try to state that, yes, I want to tell my story, you cannot just go up to the prosecutor's office. You cannot just go up to the judge, because those are the main individuals that are going to be overseeing your case, other than your attorney. And no, you would not be able to tell your side of the story up until trial, when you are basically scheduled to testify. You cannot, at the preliminary examination, it's a probable cause hearing. So the defense side is not really the area that's their time to shine. It's the prosecutor that's there to present their case. So at the preliminary examination, where it's a mini trial to determine whether you in fact will be charged with the case, no, that you can't tell your side of the story there, nor throughout the pre-trials or the actual pendency of the case. You cannot tell your side of the story to the judge. It would only be at trial. So before you're tried, before the charges are put in place, go ahead. You can talk to the police as much as you want, and that's who you would be talking to. But again, we would advise, do not talk. The only time you would really have a chance to talk is at the trial.
Yeah,
so
go ahead. Add to that. You can tell your side of the story when you talk to a defense attorney, okay? Come and have a consultation. Call us on the phone, talk to us, and then when we hear your story, we'll decide we'll be doing the defense from the beginning of the case all the way up if it goes to trial. If in some cases we may have you get up and testify. I've had some cases with clients, they didn't talk to the police, but they didn't get their statement out till trial, and we were able to get not guilties. We were able to prevail, although there are some situations where you don't testify even at trial, because we in case by case situation, we got to know, you got to talk to your attorney, get an attorney, talk to an attorney, give your story to the attorney, and the attorney will decide, will have the wisdom to decide what to do with it. But you don't want to talk, like we said, when it comes to the police, zip it. Give your name to the police. Give your real name. Don't give a fake name, because you can get charged with that. So give your name. And you can, if it goes to trial, you can have witnesses that come in. They may be in a better position to tell your story than you. It just depends on how you present. I know we'll probably have some other sessions where we talk about how you dress. When you come to court, you want to dress a certain way. You want to look professional. You want to be respectful when you talk to the court, when you talk to the judges, the prosecutors, and because the way you look, unfortunately, that can dictate what happens with your case. It shouldn't be that way, but that's the way it is. And also, and Rita and we've talked about this, listen to your lawyer. You did not go, in most cases, you didn't go to law school. We went to law school. We know the system. So I know you may want to listen to Boo Boo Ray Ray on the street, but did Boo Boo Ray Ray on the street, did they go to law school? No, they did not go to law school. So listen to your lawyer. And if you have a lawyer, I hear this too. Some people are like, some lawyers they're not listening to me. Okay, well then, if you're having a problem with your lawyer, go get another lawyer that is going to listen to you. But you also need to understand. Don't. I had a case. I had a couple trials ago. The client kept wanting to do certain things in the trial, and I kept saying, "No, we're not going to do that. You trying to lose this case?" And he kept wanting to do stuff. I said, "No, we got to not guilty." So we are lawyers. We have gone to school. We have had to take the bar exam. We know the process. So listen to your lawyers. Also that other question about if I get arrested during the pandemic, don't go out. Don't go out. I've heard about some street parties in Ann Arbor and Detroit, Ypsilanti. Don't be going out there and getting yourself put at risk that you're going to get arrested. And if you get arrested, I know there are lawyers. We're here. We can try to help people find it out. But if it's like if you're charged with something that's really a violent offense, it'll be harder to get you out. So really lay low.
Okay. So the next question is, what can I do if my municipality has selected to opt out of the MMFLA or MRTMA?
Okay, awesome question. The MMFLA is essentially the commercial side of being able to get into it medically, and the MRTAMA is the taxation of the medical and essentially the adult use recreational portion that was subsequently passed thereafter. The unfortunate reality is that if your municipality has selected to opt out, you can't do those businesses in those cities. So what do? You go to another city. I'm a native Detroiter. I, with my husband's company, Michigan Agricultural Services, which is a grow facility, we were seeking to try to engage in the business in the city of Detroit. But obtaining the real estate in zoned areas, the being able to get the license, there was a lot of, in my opinion, financial, political barriers for us. So we went out and sought another city. And so sometimes you have to do that. There are other cities who have elected to get into the cannabis business. So you just have to go that route. Hopefully, the city that you're in, some cities take a wait and see approach. They want to see how the other cities make money before they decide to do it. Who knows to say that just because your city isn't in now doesn't mean that they won't get in later. But if you want to get in now and your city's not ready to do it, then nothing's stopping you from trying to seek to do it elsewhere.
Okay, so Attorney McPhail, thank you for your response. This is from Faye Milton, this person that asked a question previously. My question is, what was the differences? This is to clarify the previous question. What was the differences in any sales licensing for any business via brick and mortar and e-commerce online sales fee? She's a female.
Okay, all right. Well, essentially, all businesses, for the most part, have some type of regulation scheme or require a licensing for some part. Let me tell you very specifically with the cannabis regulation, marijuana, you need to have the licensing that permits it. My job primarily is to make sure that people don't go to jail. I like to ensure regulatory and compliance with my clients. So if I have individuals who are trying to do online sales with seeds, edibles, there's no direct language that really provides that. So I really err on the side of caution. You have to be careful and understand not only the substance of your business, if it's marijuana in this case, you understand the commodity itself, but you have to understand also the law that regulates it and govern yourself accordingly.
Okay. So the next question is, it sounds like in Michigan, only the rich and privileged will be able to get into the cannabis industry. Is there a movement to try and change the law to allow more diverse entrepreneurs to enter into this type of business?
Yes, there is. It's the social equity statute. It's not perfect, but it's the only legislation right now. The social equity statute, again, I talked about it earlier, provides for essentially financial discounts on the licensing fees. Some There are organizations that are trying to work with the state to actually provide some type of funding or capital for people to get into the business. Um, and where that money, the source of that money ultimately will come from, I don't know. But there are organizations, there is a movement to ensure that those who were normally on the prosecutorial end of our drug laws are able to get into the business. Um, it's expensive. It just is the nature of the beast of this industry. Just even finding the real estate, you have to be able to purchase the land in the zoned areas. And trust me, once people learned what kind of property they had, that $10,000 lot became now $100,000 to buy it. The building that was now maybe 50,000 was now $1 million to purchase. So it's just expensive. It is what it is. I see movements. I've been a part of them that not only necessarily trying to be a principal and own one, but to give people an opportunity to invest. There are companies that are underfunded, marijuana companies that are underfunded that are looking for investors who want to share in the profits. Um, my my husband's company was one that was taking on investors. Let's see, there are a multitude of others that I represent. If you call my office 248-419-2889, I can direct you to some of the consulting agencies that work with some of these cannabis companies to that help with investments and investors and discuss with you what the investor initial capital lead to get in and what the payout will be and discuss the numbers and just be a wise consumer. But there is opportunity, especially when it comes to African American ownership in this. Again, it's a collective effort. Sometimes where we all can't get the license to have one, but we can help that one or those two or those four licensee holders and gain from this. I operate on kind of my own mantra of everybody should eat, and the cannabis industry definitely provides an opportunity for people to eat. So you need to get in while you can.
Right. And I know for the Redemption Coalition, some of the members that have been active with us, if you go to my website, therobinlegal.com, or call my office, 734-769-0001, so 0001, I can connect you with some of the partners that have come with us when we've done our expungement workshops that come out from them. They're advocating for more Black people. I know Rick Ross, when he was here in December, he said if we need to have him come out and be a part of some events, I mean, now with social media, we could probably, I don't know, maybe set up a separate session and have him come in and talk about getting into the marijuana industry, because he definitely wants to increase the number of African Americans and we should have opportunities. It's just all, a lot of times we'll see other people out there, they're making a profit and they're selling it to us, and it's messed up. We've been incarcerated and charged criminally. We face the penalty, and it's just not right. Equity demand.
And we'll be the number one consumers.
Right.
We'll be the number one consumers, but we're not sellers.
Right.
And to piggyback off of what Robin was saying is that, it's great that Rick Ross is doing this movement, but we have local people here in Michigan that are doing this movement. They're here. It's just about them having the platform to be able to get the information out, to be able to inform others. But again, please call my office. I know so many different entities that are looking for funding or opportunities to get in. Maybe you're a person that baked cakes, now you want to do edibles. Maybe you're the person who used to be the janitor and clean the school, but now you want to clean at somebody's provisionary center. You know, there is a way, a pathway for everyone to get involved in the cannabis business, despite what your background is. You just have to know and be connected to the right people, and this information is free. There's an opportunity to meet and network. Again, please call my office, 248-419-2889. There are several organizations, Agritech Consulting, a series of others that work with individuals getting invested from all the areas of cannabis, and there's so much. I just used the other day that somebody was making cannabis ice cream and planned on providing ice cream at under the micro business license for the summer. I guess if that's your thing, is interesting enough. They've already have markets for it. They patent some flavors, I think. I don't know, but there's where there's a will, there's a way. I'm gonna mute my mic now.
So the next question is, how do I appeal a criminal conviction, and what are the steps and timelines? Now, in terms of a criminal conviction, once you have a conviction put in place, that's when your timeline begins to run, that you have allotted to be able to file for a request to an appeal. Now, be mindful that appeals are not automatic. It depends on what type of how your conviction actually came through. Now, if you were convicted via a jury trial or a bench trial, you would have an appeal by right, meaning you would have an automatic appeal that an appellate court would be just automatically have to evaluate your case and review the case to determine from what allegations you want to appeal, determine whether your appeal is actually is justified. Now, if you took a plea, meaning what you did is you went before a judge and you were put under oath and you went through a battery of constitutional rights and you actually admitted to the crime yourself, and then basically you then were sentenced, that is a matter where you made on your own, you made a decision to admit to the violation and you entered a plea. And so then you would basically, if you wanted to appeal that matter, it would be an appeal by leave. And what an appeal by leave means is that you would have to request that your matter be heard, your appeal be heard by the Court of Appeals. And then the Court of Appeals would, by reviewing the case and reviewing the initial allegations that you would like to appeal, they would determine whether they are believe there's enough that they would want to proceed to actually hear and determine and decide your appeal. And so that if you ever take a plea, basically an appeal is not automatically granted. Now, meaning an appeal is not an actual a reversal of the case, and it's an actual, is your appeal, is the appellate court going to be willing to hear your case? So in terms of the timelines, once you actually a conviction is put in place, there is a specific timeline that is put in place that you have from the time of your conviction to the time that you would have to put in your request to appeal. Now, in terms of a trial versus a plea, you would definitely want to talk with your attorney, because your attorney is the one who would be determining whether they believe there's enough to appeal. And then your attorney would be the one to determine what timeline would actually would apply in your case. Because if it was, if you were a person that was indigent and you were requesting an appointed attorney, that timeline would be different from a case where you actually hired an attorney to represent you on your trial matter. And you would have probably less time to appeal. So if you are such, for example, if you're in prison, and you are just requesting an attorney to represent you on appeal, you would have a certain amount of time to send in your request to the court to have an attorney appointed to then file for leave to appeal or to appeal your matter. So really, these cases, they vary in terms of the timeline. It really depends on what status you are. And then again, like I said, you have to make sure versus a plea versus a conviction, because a conviction, a jury trial, you would basically, it's an automatic right to appeal. And if you are looking to appeal your conviction, regardless of if you're on the mend or you're kind of on the sideline or just teetering whether I want to appeal, I would immediately request the matter to be appealed, regardless of if you're thinking about it or not, because you don't want to even think about the timeline or what. So once a conviction is put in place, I would either request an attorney, and then if down the line you determine that you don't want to appeal and you change your mind, you could always rescind your request to appeal. But regardless, timelines or not, once a conviction is entered, put in your request to appeal immediately. So at least you protect your rights on that aspect. Now, the next question is I was pulled over and I didn't violate any law. Do I have to give the officer my ID? I'll open that up to the panel.
Yeah, I'll start with that. What I would say is this is not, because I've had, as I said, I do those educational videos, and then I've had clients showing me where they're fighting with the police, and I'm like, when I partner with Detective Brian Fountain from the Detroit Police Department, and we're always talking about comply now, complain later. So this is not for you to get into a dialogue with the police officer about whether you ran the light or whether you broke anything like that. So I would hand over your ID, give your legal name, give your real name. Don't give your relatives' names, because you can get charged for giving a fake name. But just hand over the ID. Typically what they'll do is they'll look up your name. They're going to see if you have any outstanding warrants. And sometimes that may just be left at that. If you don't have any warrants, they say, okay, they leave you alone. And I know people get upset about that. I'm being harassed. Okay, well, there's, you can call the ACLU, you can call, you can make a complaint with the police officers, commissioners, and everything like that. But give your license, give your registration, give your insurance. Now, I know for folks that are in the inner city, some of them may not have, maybe they don't have their insurance. Give what you have, and then if you get charged, you call a lawyer, try to get a lawyer to help you. If you get certain charges, like if they say you didn't have your insurance, but then you actually had it, you just didn't have it on you, you can get that corrected. With, you can get certain traffic offenses, you can work it out. I mean, to me, I think it's a racket. A lot of people talk to you about that. It's a racket where you'll get stopped for speeding and they'll give you an impeding and give you a fine so you can avoid getting points. So, but hand over your license. Don't get into an argument with the police. They typically have a gun. You don't. And then that's another thing. We could have a whole nother session about the issue about guns in your car. You can't just have a gun in the car without having a license to carry, because a lot of people think it's open carry. I mean, it isn't open carry in certain places, but again, in Michigan, and if you're Black in certain places, there's more stringent rules. So if you have a gun in the car, but back to the original question, hand over your ID. I mean, if they stop you on the street, they should just be able to do a pat down. They shouldn't be asking for your ID. You can ask them politely, officer, am I permitted to leave? Am I under arrest? Not under arrest, and say, Your Honor, not Your Honor, but say, officer, I'd like to leave, and then just leave and walk. I mean, they just passed too. They had a case that we're talking about the passenger. Can they take the license of the passenger? No, they're not supposed to do that. But if they stop you, I wouldn't get into an argument with them, because again, they have a gun, you don't. Hand over the stuff. And comply now, complain later. Call one of us, call the ACLU. But the goal is for you to get home safely, to live to tell your tale. So comply now, complain later.
Okay, so the next question is, what is a bond and how can I be released from custody without paying anything? Attorney Burton Harris.
Bond is an amount of money that you will need to pay in order to be free. And I say that because when I frame it in those words, it's oftentimes startling, but that's exactly what it is. It's an amount of money that you have to pay in order to buy your own freedom. And oftentimes people don't have to pay anything for their freedom. They're free to be released on what we call your own personal recognizance, and that's a personal bond. When you hear a magistrate have a bond, enter a bond into the system, you'll hear a $5,000 personal bond. And people can be confused and say, wait, I don't have $5,000. And I say, I know, it's okay. You don't have to have $5,000. Now, if you get a $5,000 personal bond and you don't show up at the next court appearance, then once they catch you, you are going to have to pay $5,000. But a personal bond, you pay nothing. There is not too many things that you can do to ensure that you'll be granted a personal bond. That's more an issue for your attorney. Personal bonds, based on the court rules and statutes, are presumed to be in the best interest of everyone, the accused, the community, unless there's a showing that you are a danger to society, that you're likely to not reappear for court appearances. But thanks to the jails task force, we know that people in county jails, 87% of them that receive personal bonds reappear, and 89% of people who receive personal bonds do not reoffend or get arrested, meaning that they have proven to not be a danger to society. So the research and the law all supports people, for the most part, being released on their own personal recognizance, but that does not always happen. I am friends with some wonderful magistrates in 36th District that are very forward-thinking and believe in the law and believe that unless the prosecutor can establish that you're a danger to society and that you're likely to not reappear by your criminal history and your appearance history, that personal bonds are more than likely appropriate. You should not be assessed a bond based on simply your charge, because those are just accusations. You have not been convicted of anything, therefore you're innocent until proven guilty. So you certainly should not have a bond entered just solely based on the type of charge that you have. Your attorney should be prepared with a lot of information, either from you or a family member, if you've been charged with a crime and they have to prepare a bond argument for you. They need to know, do you have significant contacts in the community? How long have you lived in the community? Do you own property? Where do you own property? Are you raising children? Are you the sole breadwinner in your home? Do you take care of someone elderly in your family? Are you coaching Little League baseball or soccer? Are you involved in the usher board at your church? Who are you? And be able to paint a very complete picture of who you are to a magistrate or even later a judge. Because oftentimes, if you receive a bond that you cannot afford to pay, from a magistrate at the arraignment, your attorney has an opportunity at the probable cause conference and at any hearing after that to address bond and file bond reduction motions and present you as the person, the human being that you are, not just as the charge that appears on a piece of paper. So, we've said that a lot of the questions were such good questions that we could have a whole series based on those smaller issues. Bond is one that we could have an entire 2-hour discussion discussing. There are so many efforts underway in our state and across our country to overthrow our current bail system, because we are starting to see it as just, a way to keep people who can't afford to buy their freedom in jail. So that means that we're just punishing poor people, because if you have the money, you can be charged with a very dangerous crime. But if you can afford to pay the high bond, then the community is left to deal with you, someone who's committed a very heinous crime, as opposed to someone who was charged with driving without a license and is possibly being held on an unaffordable bond, and they're just trapped in the jail. So thankfully, that conversation is moving forward, and I'm hopeful that it will continue to move forward. There's pending legislation to address our failed bond system and to reform it. So, hopefully in a year, this won't even be a question of how can I ensure that I get a personal bond, because we will be seeing more personal bonds.
Okay. So, Attorney Wilkerson, you worked as in the trafficking matter as a prosecutor and as a defense attorney. So I'm going to forward this question to you. Now, does a person have to appear for a traffic warrant?
Absolutely, yes. A traffic warrant operates the same as any other warrant where you have to appear before the court. And a lot of people sometimes avoid the warrant because they feel it's not as serious as, some other criminal matter. But you absolutely have to appear before the court. And I tell people, don't try to avoid it, because the easiest way to be thrown in jail is being arrested on a traffic warrant while you're driving. And then you have to wait to see a judge and so on and so forth. So it's best to appear, walk yourself in on a warrant if you don't feel comfortable doing so. Of course, always speak with an attorney, and that attorney will know exactly how to walk you in on that warrant and have you appear on those charges. I know a lot of people also avoid traffic warrants because they feel like, what if I don't have the money to pay the ticket and then I'm going to go to jail? And that is not the case in almost most circumstances. Most judges are lenient. They understand that some people can't afford to just dish out whatever this amount is for this traffic ticket. So they'll allow payment plans. They'll allow certain people to do community service and things of that nature. So there's really no purpose of avoiding a traffic ticket even before it gets to the warrant stage, because there's always a way that it can be worked out. But you do absolutely have to appear on it, or you will be arrested like any other warrant that is charged in the criminal world. If there are any other questions, or if people do have warrants and they're afraid to walk themselves in, I do handle that at Wilkerson Law, and you can give me a call for me to speak further about it and determine what type of warrant it is exactly, and to determine the best way to handle that warrant and to get that cleared up so that you are able to have a clear license or clear your license. And I can be reached at 248-505-4237 for questions regarding any warrants that people may have.
Attorney Wilkerson, explain impeding traffic. It's true that there's a 0-point violation. That's true, correct? That yes, no one can get points. You can't get points for it.
No, you cannot get points on your license for impeding traffic. Impeding traffic, in the legal sense, mean you were some type of way hindering or blocking traffic or something like that. But it's also commonly used as a plea offer, the plea negotiation for a more serious traffic offense. So sometimes your attorney will negotiate with the prosecutor to give you that charge instead of something more serious that may put points on your license. It's always a good charge to have instead of something like a speeding. Your attorney is able to negotiate for an impeding traffic. So no, it is no points on your license, and it's better to have than other charges that carry points, such as speeding.
Okay. So the next question is, what is home invasion? I will open that up to a panel member. So the next question is, and if we can make sure our phone computers are muted, but so who would like to answer the question of what is home invasion? And if we can make sure our phone computers are. Anyone like to answer?
I'll answer that question. Home invasion is, the way I explain it is the newer version in Michigan of what used to be breaking and entering. There's no actual breaking and entering law. They call it home invasion now. And there are certain degrees of it. You can get first degree, second degree, third degree. And in each degree, there's different variations of what happened when that person entered the home. So if someone was in the home when you enter, if you entered with the weapon, all those different scenarios and variations of the crime carries a higher or lesser degree. So home invasion is basically going into someone's home without their permission, forcing yourself in or breaking in or something of that nature, and you're charged under what Michigan now holds as the home invasion statutes.
Yes, and I just actually pulled up the statute, and so it specifically says a person who breaks and enters a dwelling with intent to commit a felony, larceny, or assault in the dwelling.
Yeah, I'm sorry to interrupt, but if we can all mute our phones or our computers. Okay, yeah. Thank you.
Okay, so they're entering in with the intent to commit a felony, a larceny, or assault on the dwelling, or person who breaks and enters a dwelling or enters a dwelling without permission, and at any time while she is entering, they commit a felony, larceny, or assault. And so basically, I've encountered those. I see those sometimes with domestic violence situations as well. Like maybe a couple is together and then they break up, and but then they keep breaking up and making up, and then the girlfriend will get upset and say that the boyfriend assaulted her and that he broke in the home, and so say he assaulted her, came in the house and assaulted her. And sometimes we're able to work it out at the district court level. Sometimes we have to go all the way to trial, because I've had a lot of times where clients will say, you know, no, I live there, I have a key. And, you know, sometimes it'll be a question of fact for a trier of fact to evaluate that. And, or sometimes, I mean, I know Attorney White and I have had that at the juvenile court with some kids that get in trouble for, you know, breaking into somebody's house and trying to steal something in somebody's house. And, you know, things of that nature. So it can be different degrees. You know, it could be first, second, third, fourth degree home invasion. You know, I see that, as I said, we see a lot of those at juvenile court. We also see situations where kids get in trouble for breaking into people's cars, things like that.
So the next question is, how do I amend a PPO, a personal protection order?
I'll start on that. Like I would say first, I would say that actually kind of the preface it is, how do you get a PPO? You can file in Wayne County, you can go over to the 9th floor and you can request an ex parte PPO. And but typically there's a threshold. It's not like you can just go over there and ask for a PPO because you don't like, it's like an ex-boyfriend or you don't like your neighbor. You typically, it would, if you've had a situation and with a person where they've threatened you and you call the police and you have a police report or you have actual evidence, maybe they've threatened you on your phone or the computer, or they made actual threats. So you have to meet a threshold. You fill out the paperwork and you file it. If the judge looks at it and they feel it's sufficient, then the person can be served with a PPO. And, you know, they also have over there where they can set it up. You pay a fee. I think it's like maybe $50 to have the sheriff serve the person. And then I know Attorney White and I, sometimes we're house counsel over at KMAC, where they'll pick up people that have violated the PPO and we go over there, we do an arraignment. And then if they want to have a hearing about whether they violated, they can do that. You can also file a motion to terminate a PPO. Oftentimes we'll see that with the domestic situations where the couple make up and they don't tell the authorities and the person keeps getting arrested, and we tell the person who's filed a PPO they need to go ahead and contact the court and file a motion to terminate it and come to court, tell the judge they no longer want the PPO in effect. And then specifically as far as modifying a PPO, you can file a motion on the 9th floor as well to modify the PPO. I know a lot of things are going online now, so that might be something that I think that I don't know if some of you other attorneys can speak to that. They may have set that up where you can do it online, because I know there has been a concern. I know Judge Thomas did an interview about it, that there's been an increase of some domestic violence since the pandemic has occurred.
Yes, you can file a personal protection order in Wayne County online. You can also in Oakland County online. Each of the various circuit courts for the counties, if you go to their website, they will have COVID-19 special instructions for certain proceedings, and PPOs are on, I know, Oakland and Wayne County site. And you may not have a police report. So say right now you're trapped during this quarantine in the home with someone abusing you, and there may not be any police reports. Typically, judges will look for three specific incidents, three separate incidents where you have been threatened or abused or harmed in any way, and made to fear for your life. And if you have those three, that's typically the magic number for a judge to say, aha, I'm going to grant it. And when they grant them, they are not always going to grant them on the fly. Oftentimes, the judge for that particular day for PPO petitions, they may not find that you are in immediate danger if they don't grant it right away, but instead set a hearing to allow both parties to appear and present their sides before making a decision on whether a PPO is necessary or an order is necessary. So there are ways to get that done, but I think my takeaway that I want you all to walk away from my portion of this is that you need 3 separate incidents. Make sure you have that.
The next question was is there a difference between a personal protection order and a restraining order? If so, what are the differences?
They are the same.
Exactly.
Yeah, they're the same. So a PPO is a personal protection order, and it does not allow people to come near you, just like, you know, the words restrain, you're restraining someone from coming near you or from doing something. So they mean the exact same thing, and we use them interchangeably.
Okay. So the next question is, do any of you handle felony child support cases?
Yes, I have handled them.
Okay. And if
Oh,
you
I
can
handle them. I know Attorney White, you've handled them. I've handled them as well. Yeah.
I have well, I've done so many. I refer those out now, but yeah, I've handled those in the past.
And does Michigan have a 3-strike law? Maybe if you can maybe clarify your question in terms of relating to what are you referring to?
Yeah, what I think that question is like, I'm thinking that they're talking about how California or how under the Clinton administration they had a 3 strikes law. I wouldn't say we don't have a 3 strikes law. I would say because we have some folks that have had multiple offenses. I think it just
we have habitual offender statute.
Yeah,
that's what we have.
Yeah, we have that, and it'll just depend on what is your offense, and I mean how many times you've committed your offense. I mean, if you keep getting in trouble, are you more likely to go to jail or prison for certain offenses? Yes. If I know what Judge Margie Braxton used to say, because I had a guy, I think he had like 8 breaking and entering. She's like, you're not good at this. You need to find something else to do. You need to find, because you're not good at it. So, but we don't have a 3 strikes law, not like a California, not like that. We have a habitual offender offenses.
Well, in terms of the 3-strike law, this is where it really comes into play that you need to make sure you have a very, very, very astute, aggressive, effective attorney that's going to be there on your side to make sure they negotiate your matter. Now, when we hear a lot of these cases where people are wrongly being convicted or spending an enormous, exorbitant amount of time in prison, it has a lot to do with how is your matter, unfortunately, when we get to that point, how is it negotiated when you get to the phase that you're trying to resolve your case if you don't hold a trial? A lot of times when you have an attorney is there to negotiate your matter. And when you are charged with a habitual, such as a habitual 3rd or 2nd, that can increase the actual conviction term of years that a judge could sentence you. So if you have an attorney, that's where your attorney comes into play to negotiate and make sure that habitual is either taken off or reduced or not put into placed in factored into your actual sentencing plea agreement or resolution. So in terms of the 3 strikes, it really comes and boils down to your attorney, because your attorney is going to be the one there to negotiate the matter and make sure that your matter is properly handled and that you're not serving more time than you really should be because you have an habitual. So the next question is, I plan on seeking multiple licenses from Laura. Do I have to pay the $6,000 application fee for each license?
Hi. Okay. The state only charges you 1 license application fee at $6,000. You will, however, upon approval of your application to have multiple licenses, you will pay a licensing fee for each particular license you want. But there's only 1 application fee. Now, can you pay more than a $6,000 application fee? Yes, you can, if you're submitting more than 1 application. but the $6,000 fee only applies to one application. But you have licensing fees that will come later, and that is applied to each license you applied for. But there's only one application fee, $6,000 at the state level. Be mindful, however, that cities that you are applying to operate your businesses in charge a $5,000 application fee per license. So, for example, let's say you're applying to grow and process. You're going to grow and process. Okay. So at the city level, that's $5,000 application per license. You will pay $10,000. At the state level, when you apply for that same grow and growing license and processing license, the application fee is $6,000. But when you get approved and it's time to pay the licensing fee, it's like $60,000 for each license, so it's another $120,000. So the application fee, to answer your question, it's a one-time fee, application fee, $6,000, but it's at the state level.
Okay. Another question regarding to the marijuana industry. How does recreational marijuana work as it relates to being in my car or home?
Okay. Well, with regards to your right to possess marijuana, depending on your city that you're in, most cities have passed ordinances prior to the legalization of marijuana that allows you to possess up to a certain amount. Um, um, and depending on an ordinance, normally you could keep up to a certain amount of ounces or even up to a pound. Now that marijuana is legal, an adult can carry into their home or even have in their car a certain amount. I believe it's still the 2. If I want to say 2.5 ounces, let me just double check. So many statutes that it's a couple of it's a variation of a different few ounces. I want to say 2.5 ounces or even 5 ounces that you can personally have in your car, in your home. As far as plants go, I want to say if you're is still at the 12 plant level, forgive me if I'm missing out on the plants. I just want to double check so I'm just accurate, and you should be okay. Can you walk around or have on your persons or in your house 12 pounds? You're gonna have a problem. Can you have a have a van and have 100 plants? No. There is a limitation on that number. I apologize to the poser of the question. I don't have the specific number of ounces in plants. But yes, you can. You can do so without having a medical marijuana card. Is legalized here. You're able to do it, and you're protected on doing it. So just be on guard. There is a certain threshold on the amount, and if it's okay with our moderator, Ms. White, I'll provide that information in a second. I'm just going to pull it up so that they will have that accurate information.
Okay, so Attorney Stockdale, is there a difference between recreational and medical marijuana?
As far as the product, no. It's just your purpose. Somebody could medically, presumably, use Girl Scout cookies for their recreational use as well as their medical use. But there is a distinct difference in the sell of it. You medical marijuana can be dispersed and manufactured in your grow facilities and dispensaries, and also recreational, but not. It depends on your city. The recreational cannot be dispersed legally or manufacturally grown in a city that doesn't want to recognize it. They only say, hey, we're in it just to allow people to have their medicine, not for people to indulge on a recreational purpose. So that is the only difference, just legally what can be sold for recreational purposes versus medicinal. And that really goes back to the city that allows for it and on the licensing level that you're at. If your city has opted in, there's a licensing scheme such as the micro business license, which allows you exclusively just to do recreational. But again, you can only have that license if you're in a city that has opted in to have it. I hope that answers the question.
Yes. Okay. So the next question is.
I just wanted to add a little bit to that last topic that Attorney McPhail was speaking on, because I get a lot of people asking me, now that marijuana is recreational, can it freely be sold? It still cannot be sold freely. You have to, like Attorney McPhail said, have those proper licenses in place. So just because you can have it in your possession now does not mean that you can sell it to your friends. You still have to have the proper licenses to sell it. You can transfer it for free, give it away, but you are not allowed to sell it unless you have applied for the proper license and obtained those licenses. And you are not allowed to give it, sell it, or anything to anyone under the age of 21 years old. It still has certain ramifications and consequences behind those type of actions. And I get those questions a lot.
Yeah, I was going to say, I would also like to add, because I've had that even when I do what to do when stopped by the police, I'm dealing with the children. And that statute on the marijuana is 333.27965. And it basically, it just says that it says you have to be, it says 21, and it talks about 2.5 ounces. And if you're 18, you can get, you can have a fine, pay $100 fine, and get a civil infraction. And it goes in the statute. It talks about the different degrees, like of, if, it says if the person is less than 18 years of age, by a fine of not more than 500, or community service, forfeiture of the marijuana, completion of 8 hours of drug education and counseling. Because you got kids, like I know when I do my programs, they just think because it's legal in Michigan that it's a free for all, everybody can have marijuana, but that's not the case. You got to be 21. You can have 2.5 ounces, and it's not. There's certain places you can't have it. You can't just smoke it any old where. So it's just not. People just think it's a free for all for the marijuana.
So, Attorney Wilkerson, can a CPL holder become a licensed grower and/or caregiver in Michigan?
I think I would like to refer that question to Attorney McPhail. I've looked into that and heard different takes on that. I'm not sure how that affects someone becoming a caregiver if they have a CPL. So I'm sure Attorney McPhail may be more versed on that and can answer that question.
Attorney McPhail?
Thank you, Attorney Wilkerson. I get that question all the time. Legally, yes, you can. There's nothing that prohibits a CPL holder from applying to be a licensed grower or caregiver in Michigan. The office that administers the distribution of those licenses does not say you cannot be a caregiver or grower just because you have a CPL. Now, the issue is whether or not the county board, the county gun board, which is the regulator of your CPL, decides to at the time of renewal of your CPL, decide discretionarily to use that against you for whatever reason. Remember, the CPL is a license that I don't want to say quite a privilege, but is subject to renewal and review from the gun board. I think a lot of the myth behind whether you can have both comes from the opinion of our Attorney General or ATF and DA that believes that gun holders, especially those with CPLs, shouldn't be able to have a license or a caregiver card for medical marijuana or whatnot. So there's no law in the book that say you can't have both. But just be mindful that there's a disclosure requirement when you're applying for those guns. And if the county board decides that they particularly don't want you to have both, otherwise you won't be awarded the CPL. There could be something there, but there's nothing that prevents people from having both. There are plenty of people that have both, and just make sure you're in compliance with the laws which regarding both. There could be an issue that if you're out of compliance with your medical marijuana license, or if you're somewhere where weed is not supposed to be at, like in a schoolhouse or something, and if you have a gun on you, that gun could be used as part of a charge if you're treated criminally for doing something with the marijuana because you're not acting in compliance with your medical marijuana card and your CPL. For example, you have a CPL, but you go into a crowded building. Of course, that's in violation of what you're supposed to do. CPL, you can get in trouble for that. Likewise, with your medical marijuana card, but you smoke outdoors, which is prohibited, then you could get in trouble and be charged perhaps criminally, even though you have a card. So just because you can legally have something, if you're not in compliance with the law or conform with behavior accordingly, you could see yourself in trouble. I have seen people get charged with possession of marijuana because they weren't in compliance with their patient caregiver card, and because they had a gun on them, they got charged with either felon in possession of a firearm if they had a prior felony firearm, or some other type of felony related gun charge. So you just have to be careful. But I'm going to defer any other information with regards to that part of it to any of the wonderful ladies on the panel.
Okay, there's just one last question, and then we're gonna, given the fact that it's 1:55 now, so we're gonna be wrapping up this this segment of the People's Law School for today. The last question is, can my kids be taken away from me if I grow marijuana and use it recreationally? Just real quick, now be mindful that the state of Michigan has authority to take jurisdiction of your children if they find that your children are, there's a lack of proper care and custody of your children, either by neglect, physical abuse, or basically neglect, environmental factors such as, a dirty house, or issues that could cause basically problems to the child or children. So really, yes, you can grow marijuana. However, as long as you cannot show that there's a nexus to show that would actually affect the safety of your children, meaning that your children can still be properly cared for. So if you can, if a CPS comes and meets with you, because they're going to contact you and they're going to want to sit down with you and talk with you. And again, as we talked about in the criminal aspect, be very, very careful of what you say to anybody, a social worker, a CPS worker, a police officer, if they're coming to question you, because a lot of times they're questioning you to create or establish their case. So if you have a question, some CPS worker that asked that they want to come meet with you in your home and talk to you about the fact that you're growing marijuana in your home, contact an attorney first and have the attorney discuss it with your attorney before you proceed any further, if you can. And if you do, be mindful that a CPS worker, they have to prove that is causing some type of danger to the child. So if you just make sure everything is properly handled, and just like there's many different actual requirements in terms of how marijuana, as Miss Attorney Wilkerson and Stockdale can elaborate on, is how these actually have to be handled in your home. And I don't even think they can be grown in your home. I don't know, but make sure everything is done by the book. And as long as everything's done by the book and you make sure there's a definite separation between the contact that your children are having with this actual, this industry what you're putting together versus how your children are being cared for, you should be fine. But be very, very, very careful, because a lot of CPS workers, I don't want to be subjective or be judgmental, but there is a lot of subjectiveness in this area. So even if a CPS worker, even if technically they don't have authority to file a petition to remove your children, that may happen based on the CPS worker using their subjective assessment and getting approval from the supervisor to file a petition to remove your kids based on allegations that there's marijuana use in the home. So I'm going to wrap it up, and I would like to thank everyone for participating in this actual panel. We have As you see, we have dynamic attorneys, Black women attorneys that we're here to help you at any time that you need it, especially during this time of COVID. Just be mindful that we will have our second session, our third session tomorrow. And our main topic tomorrow will be labor and employment. And on Thursday, we will be speaking about issues regarding landlord and tenant issues. And Friday, we will be addressing issues regarding the state of the court and how the court is actually operating under this current state of the COVID-19 pandemic. Along with, we will be discussing juvenile law and educational law and some other areas. So thank you again. And I thank the panel, our dynamic attorneys that have come to bring their input in this actual discussion. So I would thank all of you, and I hope that all of you stay safe. And please, as we've all mentioned, please stay home and protect yourselves and make sure you get all the legal information and education that you can from our People's Law School that will be continuing throughout this week. So thank you. And does any of you have any final, quick, short final thoughts and statements?
I would just add quickly that when I looked at the statute, it says you can have up to 12 plants. Obviously, I would say for people that want to have marijuana grow, the options, and if they have kids, they should definitely defer to Attorney Christina McPhail-Stockdale. And anybody that has questions for me, Attorney Robin McCoy, I can be reached at 734-769-0001. My website, it's McCoy & Associates, or if for educational videos, it's Robin Legal. And thank you all. Thank you guys for being a great panel.
Yes. And Attorney McDale, make sure you talk. Go ahead. I'll let you go.
Go ahead. There is one other issue. There was a question on the recreational versus marijuana. There is an issue regarding recreational marijuana can be remediated for purpose of sales, and that's a unique, complex area. But just please reach out to me, 248-419-2889. Even though I have an Oakland County number, our office is located in Redford. Come and check us out. We're eager and ready to help people get into the cannabis industry and protect them if they're already in it.
Okay, and Attorney Wilkerson.
I would just like to thank you ladies for inviting me on this panel and being great panel co-hosts. I do handle criminal matters. If anyone have anything that's pressing that they could not get answered today, feel free to reach out to me at 248-505-4237. And just thank you ladies. This was great. And I hope everyone got their questions answered and got the knowledge that they needed from this panel.
Thank you. And lastly, our candidate for Wayne County Prosecutor, Ms. Burton Harris.
Thanks again, Victoria Burton Harris, criminal and family law, again, running for Wayne County Prosecutor. I can be reached at info@victoria2020.org as an email address, and victoria2020.org for a website. And the phone number is 313-246-2166. Thank you.
Thank you, everyone. Have a great day.